for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
Denise, there are certain constants in life, like, football on Sundays, America, apple pie, Chevrolet, and radio law talk episodes where we talk about Harvey Weinstein. What's going on with Mr. W?
Well, we're getting really, really close to trial, so now you're starting to see all your pretrial motions being brought. And Harvey Weinstein had a hard week last week because he had a lot of issues before the court, and he lost most of them. First issue was whether or not the court would order the names of two complaining witnesses to be unsealed, because they are now sealed. Nobody knows who they are. There's speculation, and the court said no, declined that request of Weinstein. The second request that also related to witnesses was there's two expert witnesses. The one witness for the prosecution is an expert on sexual assault and rape trauma syndrome, and she is going to be allowed to testify over Weinstein's objections. Now, Weinstein also wanted his own expert, and he was granted that expert who can testify as to memory. But he wanted, in addition to that, he wanted her to be able to testify as to sexual interactions and the phenomenon known as voluntary unwanted sex. The court denied that last portion.
That is huge as it comes to his defense, because we talked about this a couple episodes ago, maybe it was a month ago.
We've been talking a lot.
We've been talking a lot about it, but we specifically addressed the memory expert and this idea of voluntary unwanted sex syndrome that she had talked about. And just as a quick refresher, that is the idea that the way I interpreted it was this. Not all cases of, according to the theory, not all cases of a woman engaging in sex with a man where she doesn't necessarily want to do it are rape or are forced situations. There are situations where somebody, well, I'd rather not, but I will, and kind of a situation like that. Married couples have this. I'm not in the mood, but let's go ahead, and it wasn't high on my list, but we'll go ahead and do this. And that's kind of the theory that she was going for. Also talking about, I think, what she coined as a buyer's remorse idea, where maybe I was into it at the time, but afterwards I felt so bad and didn't want to do it that all kicks in. And the prosecution objected. They objected to that being let in. That was going to be a centerpiece, I presumed, of the Weinstein defense. And the court says, no, sorry, you can't do it. And the fear that the defense is going to have now is the belief that absent willingly engaging in sex, any other type of intercourse or sexual activity is going to fall under the umbrella of rape. That's the defense's concern, and they didn't necessarily think it was that cut and dry. So,
right, I think it comes down to consent.
It does.
It does come down to consent. I think that's why the court tried to limit it and not confuse the issue.
It's interesting. We talked about last segment contracts of adhesion.
Yeah.
The take it or leave it.
Yes.
And I think to a certain extent that's what the victims are alleging here is they wanted to be actors. They wanted to be in Hollywood. And they are essentially alleging that Weinstein presented them with, I guess, what you would call a condition of adhesion, no pun intended, where they said, hey, look, if you want to be in Hollywood, you got to sleep with me. Take it or leave it. That's what they're alleging. And they were
some of them are alleging rape.
Yeah, some of them are alleging rape, but some are alleging that condition applied, and that they felt like they had no choice but to go ahead and comply with that. And the ability for the Weinstein defense to say, well, they could have just decided not to have a career and not have sex with him, but they wanted to do it. I think the court's going to look at that, and that is going to be removed. It's going to be a tougher road to hoe for Harvey Weinstein.
That defense now is not going to be offered. Weinstein also asked the court to dismiss 2 counts of predatory sexual assault. He argued that it requires the defendant have committed an underlying crime and had engaged in an aggravating crime. So he's trying to make it more proof on the prosecutor and a little harder for the prosecutors to prove the predatory sexual assault claims.
Yeah, I think one of his arguments there was that the predatory sexual assault component of that element actually, the evidence to support that element against him occurred before that was a violation of the law. And so this is where he is trying to argue the term is ex post facto,
yes.
where you shouldn't be able to be prosecuted for something that happened before it was a violation of law, and everybody thought that. Cal, you have a comment?
No, I was just going to say, I find it interesting that he basically is throwing every piece of pasta on the wall to find one that might stick. And in every case so far, the judges have said, that one ain't sticking. Nope, that one's not going to stick. See you down the road, right?
Well, except for as to the experts, he did get part of what he wanted for his own expert.
But isn't it interesting, though?
Yeah.
And arguably, if I'm the prosecutor, I kind of welcome this for this reason. I don't want, after I get a conviction, if I'm a prosecutor, think I'm going to get one, I don't want, after the fact, Weinstein to say, this should be overturned because of ineffective assistance of counsel, because my attorney did not raise these issues.
Right.
So to a certain extent, you can be upset as a prosecutor, or you can say, this attorney is really helping me ensure the integrity of the conviction after I get what I think I'm going to get.
Right, and Weinstein also sought suppression motions. These are where you try to keep evidence out, and you do that in the beginning. And that evidence was from a search warrant for 3 email accounts. There were 2 work and 1 email. And this is a fun one because what the court determined was that the Weinstein Company had a employee handbook, and it said in there that all of the emails were the work product of the company. So they're all work emails, and they're not private. So no individual could raise privacy rights as to those email accounts.
Yeah.
So he lost the suppression motion as well.
Yes, and just to let you know what the suppression motion is. These are challenges primarily under the Fourth Amendment to the Constitution. The Fourth Amendment says that no search shall occur no arrest shall occur except by probable cause, and searches shall be pursuant to a warrant. And the burden of a warrant, a magistrate or a judge can't issue the warrant unless the judge has probable cause, as stated, to do the search. In order to challenge that, before you even get to whether or not it violated the Constitution, you have to prove and show to the court that you are somebody that had an expectation of privacy in the thing that was searched or seized. So if I'm in my house, I have an expectation of privacy in my house. If it's my car, I have an expectation of privacy in my car. What the court is saying here is, look, this was a search warrant for emails of the Weinstein Company. And because the employee handbook said it's the property of the company, not you, Harvey Weinstein, you don't have an expectation of privacy in it, he loses. And those come in. If he had won, then the emails stay out. But
right. And there were 2 more requests. One was the motion requesting the personnel records of a detective that had been involved. That was denied. And then the court granted the request to inspect the grand jury minutes. So mostly Weinstein lost, but he did have some wins.
The request for the personnel records, some people might wonder, well, why would you want the personnel records of the detective? And the reason why is, in California, we call them pitches motions. And what it is let's say somebody filed a complaint against the police officer for some violation, unlawful use of force, or they had a previous Brady violation where they had failed to disclose evidence or something like that. Those things would be contained in the personnel file. So they're looking to see if there's something in the file that could be used to attack their moral character, the ability to tell the truth. And the court said, nope. So
that's right. And why would you want the grand jury minutes?
Probably for the same reason, just to see what was presented, to see if anything was untoward.
Go to the website, radiolawtalk.com. That's radiolawtalk.com.